Hi, welcome everyone to today's live session on succession planning. I would like to give a start, like to start with a brief about Taxman. We are the leading publisher of tax and corporate laws in India. We maintain the largest and most accurate online database on income tax, international taxation, GST, company and SEBI law, IBC, FIMA banking and NBFC, competition law, accounts and audit, and Indian acts and rules. Over the years, we have worked strenuously to offer the solutions that will continue to help you grow your practice. Our 6 decades of experience in the domain has helped us to constantly innovate and enhance our services to take the tax practice to newer heights. We have developed the national website of Income Tax Department and we maintain it with the help of our tech team and the editorial. I also welcome Ms. Bijal Ajinkya, our speaker of the evening. Hello, ma'am. Good evening. Ms. Ajinkya is a partner in the direct tax, private client, and investment funds practice groups in the Mumbai office of Khaitan and Co. with over 20 years of experience. She has also been recently nominated and awarded as one of the Asia's top 15 female lawyers by Asia Law Business. We are pleased, we are pleased to have you with us, ma'am. Now, before we proceed, quick few tips. All of you will be on mute. However, please post all your questions in the chat box here on your right hand side. You already have wishing us, talking to us in the chat box. All your questions will be answered by the speaker during the session or after the session by our R&D team. So don't worry, we'll try to make sure all your questions will be answered. Just make sure you put forward all your questions in the chat box. Now, without taking much time, I request Ms. Ajinkya to address the audience and proceed. Over to you, ma'am, please.
Hi. Thank you so much for that introduction, Taxman, and for hosting this seminar. Good evening to everyone, and apologies. Technology always wants to act up at a point in time when we really want things to go smooth. So our topic for today is, succession planning, and it has become a very interesting topic, in today's day and age. And let us first examine what are the trends in succession planning, and why are people, talking so much about it, and why has it become so important. One is, I would say the families have become much more, planned vis-a-vis their wealth. And to that extent, if at all there is any sort of, a discord amongst the family members, we've seen that families would rather, consider it in their lifetime rather than leaving it to the destiny of the heirs. The second is, really the fact that a lot of the next gen, of the family, having been educated outside of India, they are very, very well aware that for a successful family business or for a successful wealth transfer, a very clear and concise succession plan is absolutely necessary amongst the family members, which is where they are open to have that discussion with their parents or their grandparents. And of course, to the extent that we are really looking at, any successful discussion, it really depends on the person who is, really leading that particular discussion amongst the family members. Another very relevant point, which I would say here, is ring fencing of assets. And ring fencing could be either vis a vis a business risk or a creditor liability, or it could be vis a vis matrimonial risk or spousal access to the wealth itself. Uh, Again, what we've seen, and I would say this is a change which I have seen just in the last 5 to 8 years, where there was always a discussion, when we would have with any family, the point which we always started with was, if you ever die. And it was interesting that families could never really look at you straight in the eye if at all you ever spoke about when you die, for the simple reason that they felt that it was just a bad omen to really think about death. And to that extent, families have also become way more open to, I would say, matrimonial breakdown of marriages, which is where they are, very open to actually speaking to you about any protection required there. Another reason why a lot of families essentially undertake some level of a planning is more from the perspective, where they do have a particular family member who has a special need. They want to ensure that post their lifetime, such a member is really looked after. And to that extent, we've seen, families ensure that there are trusts created which are going to look after such a person post the patriarch's lifetime. Then, of course, you would have constantly heard about the relocation, either inbound or outbound. as well as change of residency or change of citizenship. This again is either a part of the entire business succession, or it may just be a case where families essentially are looking at globalizing their operations itself. Moving on to the next, and this is of course the backdrop of what really troubles families the most. Let us really look at the legal milestones and the landscape within which we are operating today. One is, of course, the Hindu succession law, which essentially had been amended in, the mid 2000s, wherein a daughter is considered, equivalent to a son with respect to succession of property of parents. And to that extent, it's interesting to see how a lot of families have, essentially taken a very conscious call that as much as we may really love our son and daughter equally, to the extent that we are looking at our business assets, in a situation where the daughter is not really involved in the family business, very often they take care and bring the daughter in parity vis-a-vis other financial assets. So this is a very important amendment as I would see it. And of course, we've had a lot of HUF partitions being undertaken, especially in situations where family businesses have sat within HUFs itself. Then, of course, we have the Family Law Consultation Paper of 2018, wherein, as you may be aware, that currently under Indian law, succession to property is governed by the personal law which you are subjected to. However, there is a constant talk, at least in the last 2 decades, wherein they are saying that there should be a uniform civil code rather than a law which is a personal law which applies to an individual. And of course, India being such a secular economy, it's going to be interesting as to how this particular uniform civil code will actually pan out. The world has really moved towards total transparency, and of course, this is all in the wake of the first of the leaks, which HSBC, and of course, countries have tightened their screws with respect to introducing FATCA, CRS, exchange of information. The Indian government has introduced Schedule FA. And of course, as we say in the lighter vein, that you can run, but you can never hide. Then, of course, with respect to companies, and this is more with respect to Indian corporate law, wherein there were a lot of layers really put in to essentially lead to an unidentification of the ultimate beneficial owner. That again has undergone a change, and to that extent, we've seen a lot of promoters really plan vis-a-vis complete transparency. The abolition of wealth tax, I would say has, you may feel that the government actually is not tracking the wealth, but I would say on the other hand, the government has really fixed up a lot of loose screws wherein the wealth disclosures have only become way higher. The introduction of the bankruptcy code, and especially in situations where a personal guarantee has become much more strictly enforceable, and banks are also enforcing such guarantees, is an important milestone which India has achieved. Till the year 2017, you had a lot of promoter holdings move into trust structures, and it was often uncertain as to whether a regulatory approval was required for the same or not. In the year 2017, SEBI came up with a circular to say that if you are looking to transfer, direct promoter holding of a listed company or direct promoter holding through unlisted companies, wherein it's a holding company, you do need to follow these particular guidelines. And in the event that you're not in a position to follow these guidelines, you do need to take a special SEBI dispensation. So that's an interesting, part where the securities regulator as a regulator has also really looked at, this entire trust structure. Then, of course, we move to the entire Section 56 amendment, wherein, transfers to a trust are exempt in the hands of the trust only so long as the settlor as well as the beneficiary are considered relatives under the terms of the Income Tax Act. The change of residency rules, especially for liable to tax, and in situations where a person is not liable to tax and they are holding an Indian citizenship. If your income is more than 15 lakhs, then in that situation you are deemed to be a resident but not ordinary resident. Is again a very very interesting concept that India has introduced. There have been some key rulings recently, of course, with the most latest being that of Yash Birla with respect to an offshore trust, of how beneficiaries of an offshore trust would be taxed, etc. What's in the news? Of course, we have the entire personal guarantees, how they're really going to be triggered. The recent Supreme Court decision, which is essentially talking about fraudulent transfers and how a bank can essentially invoke a personal guarantee. Another interesting point is to note is that just because a resolution plan has been sanctioned by the bank along with the NCLT, that does not discharge a person from the personal guarantee which that particular individual has given. And that's a very important point to note, that the personal guarantee is really alive so long as the debt is outstanding, and care needs to be taken to ensure that personal assets are not really encumbered in any sort of an insolvency suit. uh, there is, of course, a lot of noise about a reintroduction of an estate duty. And a number of you would be aware that till the year 1985, India did have an estate duty as high up to an 85%. And it was at that point in time where the disclosures of wealth in India were not really high, as a result of which India realized that the administrative cost to collect the estate duty was far higher than the estate duty ever collected. As a result of which they, abolished the Estate Duty Act. However, there is a constant talk that it will be reintroduced, and it's only a question of time when we would really trigger the same. So, why do you undertake an estate planning? And I would say these are the three W's, which is why, who, when, and how. When we look at why, it's essentially just a smoother succession planning amongst generations. It is a clear succession planning which can essentially help in minimizing a dispute amongst family members, can help minimize estate duty if at all the law allows us to do that. Who really undertakes? And this is often a question which is asked to us, that is my wealth quantum high enough for me to undertake it? Honestly, whatever wealth a particular person has, that's always considered to be the best for that particular individual and his family. And to that extent, irrespective of the quantum of wealth, it would always be wise to set up some level of a plan with respect to succession. When is the right time to do it? I would say the uncertainty along with the entire COVID has left a lot of families to really wonder as to why they were so callous about undertaking their entire estate plan. And to that extent, I would always say that the right time to plan was yesterday. So it's important for families to have an open discussion with their members so as to ensure that there is a clean succession. How do you really undertake it? Yes, we will throw up some ideas in the course of this presentation, but very important to note is that there is not one size which fits all, and a combination of various succession tools may actually work for families. Why do you really plan? You are planning essentially to look after the family. You're really planning for asset protection to save you in a rainy day. You are really planning vis-a-vis, avoidance of a family dispute, as well as for philanthropy. Not necessarily your definition of what is philanthropy may be the same as that of the next generation, which is why a number of family members, they do plan for philanthropy and how do you really give back to the society, which has really provided for them. The need for the R, as I mentioned, it's asset protection, succession planning, as well as a constant nag of reintroduction of an estate duty. What are the constant challenges faced by families? One is, of course, a hesitation to discuss succession plan. And it's very obvious, as parents really age, to an extent, whether they like it or not, they are dependent on their next generation. And they somewhere feel that if they do talk about succession, then in that situation, the family members may actually not take it the right way. And to that extent, they would like to avoid any sort of a controversy at an advanced age in their life. Very often it's considered a cultural taboo. They feel that, our family issues should be discussed only in closed doors of our home, and we should not really be open about them to advisors. And to that extent, let destiny or, the law of karma play a role in a person's life with respect to the succession of wealth. Another challenge is really lack of effective communication amongst family members. And this is often the situation wherein, certain family members are, ought to, or, left to believe that, even if they do nothing or if they act as, outliers to the family is going to be absolutely fair to them and provide them a succession. But what happens to the child who has actually taken care and who has perhaps sacrificed a part of their life to take care of their families? So that's a constant, I would say, discussion with families, as to how do you really provide for a son or a daughter who's doing a lot as opposed to someone who's really not doing much. Next, and what is the fine balance? And it's interesting, when you really personally think about it, what binds or what grows a business is absolutely opposite to what binds a family. And to that extent, when we're looking at a family, you know where a socialistic thing way of really bringing up a family may actually bring about a lot of family peace and unity. However, in a business, if you're looking at a socialistic model, you would only gather mediocres and you would not really be able to progress. So to that extent, as much as you seek excellence in business, that excellence may not work in a perfect manner vis-a-vis a family matter, which is where it's a very fine balance as to how you really unite the two. And you will definitely notice that the person at the center has to really think about a lot. But I think it's interesting to see as to, and I would say, the most strongest succession plans have been situations where a patriarch is in the growth phase and not in a phase where he's actually handed over to the next generation. And this is really because, perhaps mentally he's extremely strong to really realize that what he really wants, how does he want his family to succeed to the assets he's built and to actually grow on them. Some very curious cases, and I would say, whenever there are cases such as this, it's important for our antennas as advisors to go up, because these are situations where there would be some level of a regulatory essentially, another is matrimonial relations. And of course, however difficult it may sound, what we've seen is that families have become very open to essentially undertake premarital planning vis-a-vis prenup agreements or prenup trusts. And to that extent, that's another area which has caught a lot of attention and is not as much a social stigma as it used to be in previous years. Now let's look at what are the tools of succession planning, and this is a snapshot. And as I mentioned, not one size will fit all. Trust works for some families, does not work. It really depends on the nature of assets which are really held. A will is an absolutely important document, I would say, which is perhaps required in every situation where, even if at all another, any other tool of succession planning is used. Then, of course, a shareholders agreement, a family constitution, you have family offices and the growth of family offices in India. And this is an interesting situation, especially, where a patriarch who's grown a family business, he recognizes that his next generation is just not interested in that particular family business. What I've seen they prefer to do is actually to monetize that particular family business either to a strategic investor or to a private equity player. And with that particular cash which they receive on exit, they rather actually form a family office which will essentially undertake, venture capital activity or will essentially undertake private equity or hedge fund investing. This is an area which I would say most, promoters, of significance have really begun. And it's interesting to see how they have, attracted great talent to manage the family office. The HUF, of course, though it may be a little archaic and not really relevant given the current tax system and the current wealth quantums in India, but that's another tool which a lot of families have used for succession planning. So let's look at the trust, and of course, a small break for you. That trust is a tricky thing because often, family members don't trust a trust, or there are often trust issues vis-a-vis the trustee. There are two types of trust. One is a private trust, which is for family matters. The other is a charity trust, wherein the beneficiaries are the public at large. Here we are just going to be discussing the private trust. And a trust is nothing but an obligation which is next to the ownership of property. And there are three parties, I would say, to a trust, or three, bodies in a trust. One is the settlor, or the person who's contributing assets into the trust. Always better to have the economic settlor and the named settlor as the same person. The next is the trustee. And to that extent, the trustee is the person who will be the legal owner of the assets. And under Indian trust law, important to note that the legal and the beneficial owner of trust assets is always the trustee, while the beneficiaries only have a beneficial interest in the trust. So important to note, it's not a beneficial interest in the trust property, but a beneficial interest in the trust itself. When a trust is actually being settled, the two parties who sign the trust deed are the settlor and the trustee. But of course, the person who's to benefit from the entire wealth transfer is the beneficiary themselves. A trust can be revocable, it can be irrevocable, it can be specific, or it can be discretionary. In situations where absolute control and economic benefit is desired, in those situations, a revocable trust is something which is preferred. In most cases, it is a discretionary trust which is preferred, other than cases where you are planning for a family members with special needs, wherein you want the trustee to make monthly distributions to such a particular person. If there is no issue with respect to control, and the person who's contributing the assets absolutely trusts the trustee, then in that situation, the trust which would be most ideal is essentially an irrevocable and discretionary trust. I would say the most important point while discussing with any family is to first hear them out. And there could be situations as to why they may want a revocable trust. And if we force them into making an irrevocable trust, though it may be fabulous with respect to a legal concept, what we've seen that any succession plan is successful only in a situation where the settlor himself feels absolutely comfortable with respect to the succession plan. He should not really have any barriers from an emotional or a monetary perspective that there could be issues with respect to the next generation not really taking care of the patriarch and his spouse. What are the benefits of a trust? It could possibly protect against an inheritance tax or an estate duty. We can never be sure of this because we don't have the draft law in place. It's a smooth transition of assets in the lifetime of the settlor himself. To that extent, the entire issue of getting a probate, etc., does not need to be undertaken. It provides for a strong governance mechanism, because in the trust document itself, you may mention that how much a particular beneficiary can spend in a year, or how much of a corpus distribution can be made to that particular beneficiary. So it's always interesting to see how governance mechanisms can actually be provided in the trust document itself. Then next comes essentially creditor protection or matrimonial disharmony. If at all a trust has been created way before marriage for that particular child, and provided it's a discretionary trust with that particular spouse who's having an issue, does not having any rights in it, trust can greatly benefit from the perspective of matrimonial disharmony. And of course, retaining control is always a great benefit. The next, of course, a trust is, the trust law is a beautiful piece of, I would say law, whereby, in a situation where the law is so open and allows you so much flexibility that the settler is in a position to provide for as much of his wishes in the trust document itself, and either in the trust document, or we could have a lot of material in the letter of wishes. There could be a situation of appointment of individuals as guardians in the trust document, so important to see as to how that really works. Providing for distribution of assets at major life milestones for a particular beneficiary, say marriage, education, graduation, childbirth, etc. And of course, a letter of wishes to be written by the settlor to the trustees to essentially talk about how the succession is essentially to be worked. The taxation of a trust is, pretty, it's a single point of taxation, and perhaps a trust in India is one of the only means of a pass through vehicle. And to that extent, there is never a case of double taxation. Tax may be levied on the trust income either at the trust level or at the beneficiary level, or for that matter, at the settler's level, but only at one point in time. And further distributions to other members will not be subject to any tax. Settlements of properties into trusts do have a stamp duty implication, and it would be important to look at what is the stamp duty implication on any such settlement. Again, just on the lighter note, this is a very interesting point with respect to offshore trusts, and we've often seen situations where, in cases of relocation planning, family members create trusts outside of India before they relocate to India, or vice versa. And this gives them a lot of flexibility vis-a-vis taking on insurance policies, making remittances through under the LRS, or just under making disclosures under Schedule FA or FATCA, etc. The key considerations here would essentially be with respect to who the beneficiaries are, what type of assets can be settled, as well as what is the reporting in the hands of the settler trustee as well as beneficiaries. Next, moving on to wills. This is one of the easiest ways of undertaking a succession planning, but often is the most ignored, succession planning tool which people have really taken up. A will can be written on any piece of paper. There is no stamp paper required, no green legal paper required. And to that extent, all a person really requires in order to write the will is essentially you require a testator, which is the person writing the will. You require an executor, a person who's going to execute the will at the point in time of device. The other is the beneficiary or the legatee. And the last, and very, very important, is the two witnesses. Always choose a person who is younger and more fitter than the testator, such that if at all there is ever a dispute with respect to the will, in that situation, the witness can come to testify in the court. What are the important points to be noted? One is, of course, identification of assets. And I think this is just putting your house in order. Very often, patriarchs are not really aware of each and every asset. And it is important that all the major assets are really provided for in the will itself. To identify an executor who's really going to be acting in the best interest of the, of the beneficiaries. Very, very important to note that being in the role of an executor is a very difficult job, and it is a time consuming job. So choose someone who's really a well-wisher to the family and who will actually, take that effort to essentially undertake the execution of the will. The other is, of course, identify heirs. In a situation where a particular heir is being disinherited, very, very important to write the reason for disinheritance in the will itself, so that if at all such a will is contested, the court has a very clear direction as to why this particular person has actually been excluded from the will. If at all there are minor children, very, very important to write in the will as to who you would like as the next person to take care of the guardianship of a minor child. And interestingly, this could be, you could have a different guardian vis-a-vis person and a different guardian vis-a-vis property. In the absence of mentioning any, the legal process takes over and such a person gets access to both person as well as property guardianship. As I mentioned, it's an absolutely flexible document. Testator has complete control in his lifetime. He can keep making changes to the will. Registration is not compulsory at all. You store it in a place which is a place which the family members are bound to open, looking for a will, thinking that this person would have saved their will in this particular place. And of course, though a probate of a will is required in the three principalities of Mumbai, Chennai, as well as Kolkata, in any other state a will does not need to be probated. Very important to note that in a situation where there is a will, there is always a way. So if someone wants to contest it, they can always contest what is written in a will. As These are just a few guiding principles that you talk about the immovable property. Consider whether a life interest is something which you really want to provide for, and a life interest is nothing but an interest in the for the life of that particular heir, but post that particular life it reverts to the heirs mentioned in the will. And this is very they are very famous Priyambada Birla case, wherein a husband only left her a life interest in the properties and not an absolute interest. So important to see as to what a particular family essentially is looking at. Execution and storage always becomes important, because that's where a particular person will go and look at it. As I mentioned, the HUFs, HUF is really a relic of the past. A lot of, especially where you have US persons as co-partners in an HUF, it creates a lot of issues in the US on how do you characterize such an HUF. Is it an association of persons? Is it a trust? Or, is it just a joint family business, which is, in the form of an unincorporated body? And to that extent, that's something which has always been a question. We have often seen families really wanting to actually partition the HUF in situations where you have a US person as a beneficiary, or if there are matrimonial issues or any sort of creditor claims. The family constitution, as I would say, is one of the most exciting documents and a very interesting and a very, I would say, evolved form of succession planning. And like any other constitution, I mean, as you understand what a constitution of India is, it is essentially a document which is providing insight of the family with respect to the values, the goals, the expectations which the patriarch had while really building the assets as well as building a family himself or herself. And to that extent, it's a document which is not legally binding, but it can be made legally binding by way of having trust as well as by having shareholders agreements in place. The pros and cons, I mean, of course, a con is that it's not enforceable. Another con is that, a particular family member, if he wants to be or she wants to be a black sheep to the family, they will tend to act in a manner which is non-cooperative. And to that extent, there's nothing which you can really do with respect to such a family member. The next is with respect to families' needs and aspirations can provide in the family, constitution, as well as an effective and systematic implementation and execution mechanism in India. We have quite a few, I would say, family constitutions of big, large Indian families. However, of course, not many, I would say, family constitutions have been successful. And I would say the major reason really is that, families have not really brought in the stakeholders to really evolve the family constitution while it has been drafted. A shareholders agreement is nothing but which is actually putting up in situations where you have two trusts and you have two different branches of the family being beneficiaries of the trust. In situations where you want to have a call option and a put option vis-a-vis the shares of a company, in a situation where a particular branch wishes to exit, in those situations we've seen that shareholders agreements really work wonderfully with respect to management control, voting rights, offer for sale, etc. And here's a snapshot of a well-made succession plan. First, approach the family to discuss what their real needs are. Collate assets and liabilities. look into what is the personal law which applies to that particular individual, because there could be restrictions. As an example, a person of the Islamic faith can only will away 1/3 of its assets. So 2/3 have to go as per the succession laws applicable to that particular individual. Either make a will, consider a lifetime gift. You approach situations of a family dispute, family constitution, if at all, implement whatever is the plan, and always periodically review such a plan which is put in place. With this, I would like to conclude my presentation, and I'm happy to take on any question which the audience may really have. And of course, the topic is very vast, which is why I've gone slightly faster, because I thought it would be only fair for you to get an entire snapshot. Thank you so much. Okay, so I'm just going to be moving on to questions. And the first question is, just a second. Yeah. Okay. So with respect, so the first question is, with respect to, non-resident beneficiaries, and in a situation where there are non-resident beneficiaries vis-a-vis onshore assets, as to whether or not, how do you really offshore such assets? And very important to note that because of the FEMA regulations in India, it's extremely difficult for you to offshore assets. However, it is not difficult for a non-resident to essentially inherit Indian assets. And to that extent, there are certain, structures which could be looked at with respect to creation of trusts, or with respect to, relocation planning, which could be really considered. The next question is: can a daughter have a right in father-in-law's property? And I guess you're talking about whether a daughter-in-law can have a right in father-in-law's property. To that extent, no. For a daughter-in-law, her access to her property would only be vis-a-vis the husband, and that too in situations where there are matrimonial disharmony or a divorce, which is really, being considered. The next question is whether a trust property can be attached. Yes, it can be attached, especially in situations where the transfer into a trust has only been done for fraudulent reasons. The next question is that which act states that in case of agreement being silent, the share of co-owners in a property is equally distributed. Essentially, under Indian law, where you have ownership of property, unless you specifically mention what is the split of each person's ownership, it is deemed to be equal, and this is the law in any common law country to that extent. The next question is, what is the difference between an executor and a testator? A testator is the person who actually writes his will with respect to his assets, and an executor is nothing but like a trustee who's going to ensure that the testator's wishes are implemented post the death of the testator. So he's more in a fiduciary capacity to that extent. The next question is, can an economic settler be one of the beneficiaries too? Yes, they can be one of the beneficiaries, but of course it would be important to see as to whether, such a trust would be considered a revocable trust because of this situation. The next question is as to whether the maximum marginal rate of a trust whose income, would it be the income of the trustee or beneficiary? It is always the trust income. And the maximum marginal rate, with respect to capital assets or capital gains, is the special rate applicable to such a capital gain. While with respect to any other assets, it would always be the maximum marginal rate applicable to the beneficiary himself. What is the taxation when trusts are transferred to the trust? There is no tax when an asset is transferred into a trust, so long as it is ensured that the settlor as well as the beneficiary are related parties under the Income Tax Act. The next question is with respect to the taxation of a private trust. Essentially, a taxation of a private trust is governed within sections 161 to 164 of the Income Tax Act. And it would really depend on whether a trust is discretionary or determinate, as well as revocable or irrevocable. If it is a tax which is a determinate trust, wherein the shares of the beneficiaries are mentioned in the trust document, as well as the names of the beneficiary, in that situation, a trust can be taxed either in the hands of the tax can be recovered either in the hands of the trustee or the beneficiaries, and that choice is vested with the tax officer. In the case of a discretionary trust where the list of beneficiaries is not essentially provided with their absolute share, in that situation a trust will be taxed at the trustees level, but of course on the trust pan account itself. If a trust is a revocable trust, all the income of the trust will be taxed in the hands of the settlor. Does the revised will need to be registered if the earlier will was registered? It is not compulsory to register a subsequent will, but depending on a personal situation, it may be apt to register it if at all a family member does see that there is going to be some contest to such a will. What if the executor expires? What will be the validity then? In a situation where an executor passes away prior to the testator, in such a situation, the heirs under the will can nominate one of themselves to essentially undertake the entire execution process of the will. Can you share real life challenges? So I would say real life challenges of of COVID second wave. I would say one is of course family members who did not really create their wills. They were in a panic state. A lot of them were not in a position to do it because they were on a respirator stage in hospitals. But I would say in this last almost 2 years, the number of clients who've actually looked at really getting their house in order has been enormous. And to that extent, it's more with respect to having the succession go as per your wishes rather than it go by the personal law which a person is really subjected to. The clubbing provisions with respect to Section 64 under the revocable trust apply only in a situation where the trust is settled as revocable. As I mentioned, that it would always be beneficial if a trust is created as an irrevocable discretionary trust. But of course, it depends on the specific facts of the case. Is probate required if there is no immoved property and the will? So a probate, in a situation where there is a will, a probate is required if there's immovable property. If there is no immovable property, what is required is a letters of administration from the court for administration or execution of the particular estate. How do NRIs inherit equities? Not very difficult. I mean, it can be mentioned in the will as well as a nomination essentially can be done with respect to such equities. Whether a will executed in India can be applicable to assets outside of India, yes, it can be. However, very important to note that execution of a will is a very administrative process in the courts, and it is always preferable to have a form of a will which that particular court is actually used to seeing. And to that extent, we would always suggest that if the assets in the other jurisdiction are substantial, you rather have a fresh will for that particular country. Uh, can a trust property be attached in a maintenance matter? Yes, it can be. It really depends on how the trust has been worded, as well as the rights, as well as who the settler, trustee, and beneficiary are. Uh, a property mentioned in the will is assigned to one daughter, can can the other daughter claim the same even if it is mentioned? So if a will is written, what is written in the will is really the wishes of the testator, which the executor needs to implement. So unless the other daughter, contests the will and proves in the court that this is not my parent's signature, or this is not a will which has been written by them, he's been forced, he's not of sane, he's not of sane mind, etc. Only in those situations can a will be actually contested by the other child. Uh, a property situated in Navi Mumbai, since that falls within the Thane region, does not need to undergo the probate process. It's only properties which are within the principality of Bombay itself are required for a probate. Can there be a separate will for different assets? We would not suggest you ever do that, because there could also be loans, etc., and liabilities be discharged, and it will just unnecessarily complicate the matter with respect to execution of the will. Uh, the other question is, what will be the taxation? If an LLP distributes profits to a trust which is a partner, there will not be any taxation. And if a further distribution is made by this trust to the beneficiaries because it's tax exempt income, there will not be any further tax on such a distribution. Should trust deeds be registered? A trust deed is not required to be registered, especially in situations where it is a private trust. You can bequeath both global assets, immovable as well as movable, in an Indian will. And to that extent, as I mentioned, it will always be important for each country's specific assets to actually go by way of different wills. Yeah. I think those are the questions which I can see. There's another question as to whether taxman is going to be distributing the PPT. That's taxman's discretion. I'm not sure of that. Yeah, I think we are done with all the questions. Can artificial persons be the trustee of a trust? Yes, it is permissible. And to that extent, you could have a company act as a partner, as a trustee to a trust. With respect to intellectual property, very interesting question. And of course, it will all depend on the nature of intellectual property. But if your question is whether an intellectual property can be, passed on to the next generation, yes, it can. And certain intellectual properties can also be settled into an Indian trust. With respect to property, if it is there in Mumbai as well as Bangalore, whether a separate probate would be required, the manner in which you could undertake the same is that you apply for a probate with respect to the Mumbai property, and parallelly you can have the succession of the Bangalore property undertaken. In a situation where assets are spread across states, you would have to look at what is the situs of such property, and as per the situs of the property, stamp duty would need to be paid. An Indian property cannot be registered in the name of a US trust. For that purpose, the acquisition in itself would need to be made by the US trust, which is not permissible under the exchange control regulations. The Indian Succession Act talks about the probate being required only for Mumbai, Chennai, and Kolkata. I think these are the questions. I can't see any further questions so far. With this, possibly we can conclude this session.
Yes, ma'am.
Happy to address any queries, if at all,
Yes.
the audience has by way of email. Thank
Okay,
you.
ma'am. Yes, thank you, ma'am. Thank you for this insightful session. It's definitely going to add on to our knowledge on the topic. We appreciate the time you took to prepare the subject matter and for this webinar and precisely explaining it to our audience. I'll also thank to our participants for being so cooperative. Thank you all for taking time out of your busy schedule and joining us in this session to make it a success. Though ma'am has tried to reply to the queries raised during this session, yet in case you have any further questions, you may please write to us at sales@taxman.com. We shall definitely fetch the answers and reply back to you. Thank you all once again. We shall soon be back with another vital topic. Till then, have a great time. Bye-bye, ma'am. Bye-bye.
Thank you so much.